So in the last lecture, we were doing cause of action. Fine. We had only a small class. We were doing cause of action. In yesterday's session, we were doing cause of action. Fine. So here we understood what exactly cause of action means. So first I told you that what is cause of action. So I told you that it is a pivot around which the entire suit revolves. It is basically a pivot around which the entire suit revolves. And what exactly is cause of action? It is existence of legal right and violation of the same. So existence and violation of the same is cause of action. This is what was the second thing that we understood. Then the third thing was we understood that the cause of action has to be disclosed clearly. Now, if it is not disclosed, what will happen? The defendant will not be able to take defense properly. The court will not be able to frame issues properly. So both of them will face problem. Defendant will not be able to defend himself properly, and the court will not be able to frame issues properly. So both of them will face problems. Moreover, we also understood that if you are not disclosing cause of action, then your plaint will be rejected. So the plaint will be rejected under Order 7, Rule 11A. If you are not disclosing cause of action. Okay. So if you are not disclosing cause of action, your plaint will be rejected under Order 7, Rule A. This was the second thing that we went on to understand. After this, we went on to understand that the burden of lies lie upon the plaintiff to prove cause of action in trial. So cause of action जितना भी trial में है वो उसके burden will lie upon the plaintiff to prove the cause of action in trial. Then we went on to understand the concept of breach of contract. That what will be cause of action in the concept of breach of contract. So in breach of contract, I told you that the cause of action in the cases of breach of contract, ideally the cause of action will be the existence of contract and violation of the same. So first is existence of contract, and secondly breach of the same. That will be the cause of action. Here cause of action will arise. Okay. But if you are seeking specific performance, you will have to prove an additional aspect with respect to cause of action. That will be readiness and willingness. And why will you have to prove this readiness and willingness? Because 16C of SRA requires the same. 16C of SRA requires the same. 16C SRA का ये demand करता है कि आप readiness and willingness establish करो. So that is the reason you will have to prove the same. Now this is what we understood. That's like something about cause of action. This was the first term. Terms में से ये पहला term था that we had to understand in order to proceed with the main aspects of procedure. Now procedure समझ में नहीं आएगा if you don't understand the word cause of action. Now let us understand the second term. Second term is parties. एक सेकेंड, अब कुछ इशू हो रहा है क्या यहाँ पर? सर मेक मी को होस्ट. किसको बनाओ? दोनों को? एक बार भानु आप हाथ उठाओ एक बार. बना दिया ना को होस्ट भानु को? नहीं.
Yes sir, he is co-host.
बना दिया ना, he is co-host ना?
Yes.
एक सेकेंड दे दो, स्टार्ट करो. Now the second term that we will understand is parties. Parties. Now in a civil procedure, in a civil suit or in a civil proceedings, जरूरी नहीं है suit हो, civil writ भी हो सकती है, civil proceedings. Who are the parties? Now ideally in a civil proceedings, the parties are two. One is a plaintiff. One party, the party which is filing the plaint is known as plaintiff. And the party which is defending is known as defendant. ठीक है? अब जरूरी नहीं कि plaintiff और defendant ही हर किसी में हो. सारे civil proceedings are not suit. There can be a civil writ also. In that case, the one who is filing the writ will be petitioner. The person who is responding will be the respondent. ठीक है? A civil application can also be filed. So the person who is filing the civil application is applicant, and the person who is responding is respondent. So these are broadly parties that are there in your CPC. So ideally तो आपका पाला plaintiff और defendant से पड़ेगा, but the procedure is not restricted only to these. Ideally तो आपका पाला plaintiff और defendant से पड़ेगा, but the procedure is not restricted to only these. इन दोनों में भी पाला पड़ सकता है, मतलब it can happen that these two these second and third you can also fall under second and third category. फाइन, जरूरी नहीं कि सेकंड एंड थर्ड में नहीं गिरो आप. फाइन. अब देखो एक इंटरेस्टिंग चीज है कि इट इज नॉट नेसेसरीली दैट एवरी सूट हैज टू बी A versus B. A versus B means that A is the plaintiff and B is the defendant. ठीक है, ऐसा हर सूट नहीं होगा. This is not how every suit will work. There may be a suit wherein what will happen, two plaintiffs are coming together and they are filing a suit against a defendant. This is known as joinder of plaintiff. ऐसा हो सकता है कि A and B versus C. In this case, what is happening? Two plaintiffs are coming together. Two plaintiffs are coming together. And why they are coming together? कुछ तो कारण होगा क्यों ऐसी क्या पड़ी है कि एक साथ आने की. Because there is a common question of law. Firstly, there is a common question of law. Secondly, the act is committed in same transaction. ठीक है, ये तो हम डिटेल में देखेंगे. Now, when two plaintiffs, when they come together and they file a suit against one defendant, that is known as joinder of plaintiff. अब दोनों plaintiff एक साथ join हो गए ना, so this is known as joinder of plaintiff. Now, this is something which has been provided in, this joinder of plaintiff is something which has been provided in Order 1, Rule 1. ये common है guys. This is common. Common question of law. अब देखो यहां पर जैसे this is known as joinder of plaintiff. Suppose एक land है. This is a land. This belongs to A and B both. They both are joint owners. Joint owners मतलब दोनों का आधा आधा हिस्सा है. ये बड़ा सा लैंड है and ये this part is A, this part is B's. Now there one fellow comes, his name is C. He kicks both of them out. And he takes an illegal possession of this property. दोनों को निकालता है, A और B दोनों को धक्के मार के निकाल देता है, and he takes the illegal possession of this property. Now here A and B together will file a suit against C because both of them have been kicked out by an act which is of same transaction. एक ही act है. दूसरी चीज, there is a common question of law which has to be determined. If two suits are filed, unnecessarily it will be a multiplicity of proceedings. अगर दो suit file किए, A ने अलग file किया, B ने अलग file किया, दो अलग proceedings होंगे which won't make sense. So that is the reason you are asking them to file one suit, and this is also known as joinder of plaintiff. Joinder of plaintiff. इसको बोलते हैं हम joinder of plaintiffs, wherein two plaintiffs are joined together. Fine. अब ये हो गया joinder of plaintiff. ये यहाँ तक क्लियर है? Yes, अनुकृति, आपको कुछ डाउट था?
Yes sir. तो मुझे पूछना था, आप सिविल डेटर एप्लीकेशन पढ़ाएंगे ना अपकमिंग क्लासेस में?
क्या पढ़ाऊंगा?
सिविल डेटर एप्लीकेशन वाला पार्ट.
एप्लीकेशन और रिस्पोंडेंट, एप्लीकेंट और रिस्पोंडेंट, सिविल रिट और एप्लीकेशन वाला पार्ट. हाँ वो तो ठीक है, वो कोई इशू नहीं. ठीक है,
ओके सर.
ठीक है, ये क्लियर है?
यस सर.
सर प्रोविजन कौन सा है?
Order 1, Rule 1. Order 1, Rule 1. Yes, Muskan.
Sir, you will teach this again, right? Joinder of parties later.
Yes.
This is just for illustrative purposes, for our better understanding, right, sir?
Yes.
Okay, sir.
ठीक है. Yes, dot.
So what does same transaction mean?
मरियम हो क्या अब?
Yes, sir.
अभी समझो मत सेम ट्रांजैक्शन को इस सेंस में, आगे समझेंगे, ठीक है? सेम ट्रांजैक्शन को भी एज इट इज लो, ठीक है? बाद में समझेंगे डिटेल में. So this is what joinder of plaintiff means. Now come to the second aspect. Now it can also happen that suppose there can be a joinder of defendants as well. One plaintiff is filing a suit against two or more defendant, B and C. This can happen under order 1 rule 3. ठीक है, इसको हम बोलते हैं joinder of defendant. We call it joinder of defendant. ठीक है. Now here you have seen two things. One is there are two parties. One is a plaintiff, other is a defendant, and there can be two plaintiffs, there can be two defendants. ठीक है, ये दो चीजें मुझे समझानी थी कि जरूरी नहीं कि एक प्लेंटिफ हो एक डिफेंडेंट हो. There can be two plaintiffs, there can be two defendant. If there are two plaintiffs, it is known as joinder of plaintiff. If there are two defendants, it is known as joinder of defendant. Fine. Now there is one peculiar type of defendant. There is one interesting type of defendant we call pro forma defendant. Now ये तो सही, these are ordinary defendants. ये सारे defendants, whatever you have seen, these are ordinary defendants. They have a conflict of interest. They are in true sense defendants. There is one fellow who is a pro forma defendant. Now look at the name, pro forma. When I say pro forma, I mean to say that this fellow is a defendant, but this fellow is a defendant for namesake. मतलब नाम के लिए defendant रखा है. अब ये कब हो सकता है? When can this happen? Suppose there is this property. This property belongs to A and B. They both are joint owners. Fine, they both are joint owners. Now what happens? There is this C. He comes in and he kicks both A and B. He kicks both of them out. उनको धक्के मार के निकाल देता है. A gets furious that how dare C kick us out? This is our property, our land. We are the joint owners. This is not done. So A decides to file a suit against C. A बोलता है कि I'll file a suit against C. B says, boss, I am not going to get myself involved in it. You do whatever you want. I won't go out with you and file a suit. Now this is a problem. Now if B is not made a party to this suit, now suppose if the suit is only A versus B, if the suit is only A versus C, then it is a problem. Why it is a problem? Because B here is the joint owner of the property. So he is a necessary party. He has to be there in the suit. If he is not in the suit, then what will happen? The suit will not be decided comprehensively. पूरी तरह से suit decide नहीं हो पाएगा, क्योंकि his interest is also there in this property. So that interest also needs to be decided. And in order to decide B's interest, B's presence is very important. कुछ B का interest भी है इस property में, वो भी decide होना चाहिए. अब वो interest decide करने के लिए B की मौजूदगी बहुत important है इस suit में. Now B does not want to be a plaintiff. B बोल रहा है कि मुझे इस पचड़े में नहीं पड़ना यार, मैं क्यों plaintiff बनूं? Why should I go through the trouble? So in this case, what will A do? A will make B a defendant. यहाँ पर. Now this defendant is known as pro forma defendant. Pro forma defendant. Now what does this mean? That this fellow B is a defendant, but he is defendant only for namesake. He does not have any conflict of interest, or he does not have any conflict with A. उसका कोई विवाद नहीं है A के साथ. In fact, if we have to analyze it truly, उसका रियल में विवाद है co-defendant के साथ. He has a dispute with the co-defendant. If we have to analyze it very closely, so it can mean that he has a dispute with co-defendant. Now यहाँ पर the suit is A versus C. and B is the pro forma defendant. Now, if you analyze B's position closely, he is only a defendant, not because he is truly a defendant. He is only a defendant for namesake. He does not have any dispute with A. कोई झगड़ा नहीं है उसका A से. Rather, उसका झगड़ा है C से. Fine, उसका झगड़ा है C से. So this person has been made pro forma defendant. The reason this fellow has been made pro forma defendant, so that the suit can be decided comprehensively. So that in future such a situation does not arise that B comes to court again and B said that you have decided my title without making me in presence, without obtaining my presence, without calling me in presence, and he obstructs the decree. ऐसा ना हो कि फ्यूचर में B आ जाए सडनली कोर्ट में कि आपने मेरा टाइटल तो डिसाइड कर दिया बट मैं था ही नहीं वहां पर, and he ultimately obstructs the decree. So for that reason you are allowing B to be present, but not as a plaintiff, because he does not want to be a plaintiff. So you are allowing B to be present only as a pro forma defendant, that is a defendant for namesake. In reality, this fellow is not a defendant. Why is not a defendant? Because he has no conflict with the main plaintiff. Rather, he has a conflict with the co-defendant. जो उसका झगड़ा है वो साइड के डिफेंडेंट के साथ है, मेन उसके साथ नहीं है. So this is something known as pro forma defendant. ठीक है. अब pro forma defendant के साथ क्या होता है? Pro forma defendant के साथ क्या होता है? एक इंपॉर्टेंट चीज होती है pro forma defendant के साथ कि फ्यूचर में what happens that these pro forma defendant can be transposed. What is transposed? एक ट्रांसपोजिशन हो सकता है pro forma defendant का. What is transposition? ठीक है, एक ट्रांसपोजिशन हो सकता है. What is transposition? पहले तो पोजीशन क्या है? पोजीशन and trans. So basically you are changing the position. So in future the court can conduct a transposition. Now how will the court conduct a transposition? Court on the application of the party will make this pro forma defendant a plaintiff. यहाँ पर plaintiff बना देगी इसे. B था ना pro forma defendant, sorry, B था pro forma defendant. ये तो C के खिलाफ तो विवाद था हमारा. B was the pro forma defendant. एक सेकेंड. B was the pro forma defendant. So basically court will make this pro forma defendant a plaintiff. Court will change its position from defendant. Court can make him plaintiff. So this is something known as transposition. So transposition means that you are converting a defendant into plaintiff. So यहाँ पर जो defendant था उसको court ने plaintiff बना दिया. So this is known as transposition. Basically you are changing the position of the defendant, changing the position of the party. ठीक है. Sir, your voice is breaking. Oh, it is breaking.
No, sir. It's clear.
Sir, your voice is breaking. नहीं, clear था. Clear, sir. थोड़ा धीरे से. ठीक है. Whose application? On whose application? Not breaking, it's fine. Transposition not clear. हाँ, transposition बोले. ठीक है. I didn't get it, sir. Please repeat. Yep. Yes, Arthak.
सर इसके अंदर सर ये बता दीजिए कि किसने डिस्पोजेस करा था सर, बिकॉज नेमिंग ऑफ द सूट के अंदर सर थोड़ा क्लैरिटी नहीं.
ठीक है. यस नूर.
सर जो प्रोफॉर्मा डिफेंडेंट होगा तो वो मतलब डिफेंड करेगा अपना केस?
नहीं, डिफेंड नहीं करेगा. वो डिफेंड कर सकता है. ही कैन चूज टू रिमेन साइलेंट आल्सो. उसकी मर्जी है.
मतलब उसको कुछ भी रिटन सबमिशन या कुछ नहीं देना पड़ेगा?
नहीं देना पड़ेगा. अगर उसे नहीं देना, ही कैन अवॉइड इट. उसका सिर्फ प्रेजेंस आप सिक्योर कर रहे हो, बट उसे देना है तो फिर कोर्ट ट्रांसपोज भी कर सकता है. उसे बोल सकता है कि ठीक है, तुमको लड़ना है तो आप प्लेंटिफ बन जाओ.
ठीक है सर, थैंक यू.
ठीक है सर, दिस इज नॉट क्लियर. वेट, आई विल जस्ट रिपीट इट. चलो, A and B are joint owners. Does it happen in practical sense? It happens every time. ठीक है, A and B are joint owners. ठीक है, C kicks A and B. C kicks out A and B. C निकाल लेता है A and B को, सब धक्के मार के निकाल देता है A and B को. Fine. Now what happens? A says that, see, I want to file a suit against C. B says, boss, I don't want to get into this mess. I don't want to file a suit. आप अपना देख लो, आप फाइल कर दो suit. So here अब क्या है, प्रॉब्लम क्या है कि B's present is necessary. B's presence is very important because B is a joint owner. B's presence is very important. B का presence बहुत ही important है. अगर B नहीं होगा तो क्या होगा? B has a position. B can obstruct the decree in future. Future में क्या कर सकता है? B can come to the court. B can say that, see, you have decided my title. आप लोगों ने ये सूट में मेरा टाइटल डिसाइड कर दिया A वर्सेस C में, और मैं था भी नहीं. ये प्रॉपर्टी के ऊपर ही डिसाइड करना है ना, ये कोर्ट तो पूरी प्रॉपर्टी के ऊपर डिसाइड करेगा. तो B बोलेगा कि यार आप लोगों ने मेरा टाइटल डिसाइड कर दिया एंड मैं था नहीं. सो B हैज अ कैपेसिटी टू ऑब्स्ट्रक्ट दिस डिक्री को रोकने की कैपेसिटी है. सो दैट इज द रीजन व्हाट द कोर्ट विल डू. कोर्ट विल मेक दिस B एज अ प्रोफॉर्मा, मतलब कोर्ट विल A will include this B in the suit and he will make B as a pro forma defendant. यहाँ पर pro forma defendant बना देगी. Now this defendant will be a defendant, but that defendant will only be for the namesake. सिर्फ नाम के लिए defendant होगा. जब मैं बोलूं नाम के लिए defendant होगा, means that he will have no dispute with A. A के साथ तो इसका कोई विवाद है ही नहीं. इसकी जो dispute होगी वो C के साथ होगी. उसका जो डिस्प्यूट है वो को डिफेंडेंट के साथ है. ही हैज नो डिस्प्यूट विद ए के साथ तो कोई डिस्प्यूट नहीं है, विच इज द ओरिजिनल प्लेंटिफ. इसके साथ कुछ डिस्प्यूट नहीं है, इसका डिस्प्यूट है को डिफेंडेंट के साथ. सो ही इज अ डिफेंडेंट बट ही इज फॉर नेम सेक. अब क्यों नेम सेक के लिए? क्योंकि उसका कोई डिस्प्यूट है ही नहीं प्लेंटिफ के साथ. No dispute with plaintiff. So that is the reason you cannot say that he's an active defendant. So इसके लिए क्या होगा? This person will be in future. In future, the court can transpose him. Court can decide to transpose him, and court can make this defendant a plaintiff. Future में court इसको plaintiff बना सकती है अगर चाहे तो. Fine. So this is what it is. This is what is pro forma defendant. Why not pro forma plaintiff? Why only pro forma defendant? एक समझो, रुको, ये पहले मुझे आंसर करने दो. Why not pro forma defendant? Why only pro forma plaintiff? सुनो, pro forma plaintiff कैसे हो पाएगा? प्लेंट कौन फाइल करता है? The person who files the plaint is plaintiff. This fellow is not filing anything. डिफेंडेंट आप खुद अपनी मर्जी से चुन सकते हो. प्लेंटिफ तो खुद ही फाइल करते हो ना. प्लेंट फाइल करते हो तब प्लेंटिफ बनता है. प्रोफॉर्मा प्लेंटिफ तो बन ही नहीं पाएगा जब वो प्लेंट ही फाइल नहीं कर रहा. डेफिनेशन ही से हु इज अ प्लेंटिफ? एनी पर्सन हु फाइल्स द प्लेंट. दिस फेलो इज नॉट विलिंग टू टेक पार्ट इन द लिटिगेशन. सो दैट इज द रीजन this fellow won't be a pro forma plaintiff, it will be a pro forma defendant. ठीक है सर, on whose application the court can transpose. ठीक है, it can be so moto also on the application of plaintiff also or defendant also. ठीक है, on the application of any party. वैसे तो fine. Does it have a practical sense? I mean, C can always say that his and these interests are contradictory. ये तो आंसर करने लायक नहीं है. If pro forma defendant wishes to plead only then he will transpose. Is that correct? Yeah, only then he will transpose. That is correct. Sir, plaintiff बनने से होगा क्या? He can plead ना? He can plead. He can actually actively litigate. Sir, on whose application? Any party. ठीक है. Yes, Muskan. Yes, Muskan.
Sir, I understood the concept of pro forma defendant, but I didn't understood what is transposition.
Transposition क्या है? कि यहाँ A है, ये वर्सेस B है, और ये C है. B is the pro forma defendant. ठीक है, तो इसको आप plaintiff बना रहे हो. Court in the middle of the proceeding is making it plaintiff. Transposition, changing the position of the party. अब clear है? अब clear है? When he decides to plead, तो ये होगा. So this is done in order 1, rule 10, sub rule 2. Fine. चलिए अब लिखिए. अब क्लियर है गाइस? आगे बढ़े. थम्स अप दो जल्दी. क्लियर है तो आगे बढ़ो. यस सृष्टि.
सर
प्रोविजन तो चलो लिखवा रहा हूँ. कॉन्सेप्ट क्लियर है. प्रोविजन के ऊपर.
यस सर यस.
कॉन्सेप्ट क्लियर है. प्रोविजन लिखवा रहा हूँ. प्रोविजन डोंट वरी. The pro forma defendant is made plaintiff only when he wants to plead, or there are other circumstances also. There are other circumstances also, but usually only when he want to plead. ठीक है. अब देखो pro forma plaintiff क्यों नहीं बनेगा. I'll repeat that part again. See, who is a plaintiff? One who files the plaint. ठीक है. Plaintiff कोई तीसरा बंदा आपको नहीं बना सकता. A third person cannot make you a plaintiff. प्लेंटिफ आप तब बनोगे जब आप खुद कोर्ट में आते हो, कोर्ट में प्लेंट फाइल करते हो. फाइन. तीसरा बंदा आपको नहीं बना सकता. डिफेंडेंट थर्ड पर्सन कैन मेक यू. तो इसलिए प्रोफॉर्मा डिफेंडेंट, इट वोंट बी प्रोफॉर्मा प्लेंटिफ. ठीक है. चलिए लेट्स सी. तो लिखो प्रोफॉर्मा डिफेंडेंट. ठीक है. व्हाट इज ऑर्डर लिखा रहा हूं. प्रोफॉर्मा डिफेंडेंट, अ डिफेंडेंट who ought to have been, who ought to have been a plaintiff, but becomes defendant, a defendant for namesake. ठीक है. He is known as pro forma defendant. अब नाम ही देखो ना कि pro forma means only to fill the form you are making him defendant. Now why you are making him defendant? Since he was not willing to become plaintiff, become a plaintiff. ठीक है. ये लिख लिया. आगे बढ़े. Should we press?
Yes sir.
Yes, Chitrangada.
So who can make this application for transposition?
Any party and even court suo motu.
So then that means the status of pro forma defendant as a plaintiff can be forced upon the pro forma defendant.
No, you will give him an opportunity to be heard before passing an order of transposition.
And still, if the court feels that he should be a plaintiff, then he will have to.
Then he will have to. Fine. Yes, Anukriti.
सर ये ट्रांसपोजिशन प्लेंटिफ में भी होगा कि सिर्फ डिफेंडेंट में होता है?
दोनों में होता है, बट ज्यादा कर होता है प्लेंटिफ में. ठीक है.
ओके. थैंक यू सर.
चलिए आगे बढ़े.
Yes sir.
So any defendant who does not have conflict of interest, with plaintiff, rather he has a conflict of interest Rather, he has a conflict of interest with other defendant. With other defendant. Rather, he has a conflict of interest with other defendant, that is co-defendant, and he has been made the defendant only for the namesake. Only for the namesake. ठीक है? Such he will be called pro forma defendant. He will be called pro forma defendant. He will be called pro forma defendant. And now why it is important, why his joinder is important, why is important to join. Now joinder of such a party as a defendant becomes essential as normally he will be a necessary party. Normally he will be a necessary party, and if he is not joined, he will be a necessary party, and if he is not joined, then he has the capacity to obstruct. Then he has a capacity to obstruct the execution of decree. ठीक है? Now, यहाँ तक clear हो?
Yes.
आगे बढ़े, लिख लिया सबने?
Yes. Just a minute.
So 1 minute.
What is the order? Order 1, Rule 10, Sub Rule 2. कोई तो डाउट नहीं है मेरे हिसाब से. बढ़े? Should we?
Yes, sir.
Such a plaintiff, such a defendant of transposition, such a defendant normally would be transposed under Order 1, Rule 10, Sub Rule 2 to the position of plaintiff. To the position of plaintiff at the trial. Position of plaintiff at the trial means that at the point of leading evidence at the trial, ठीक है, the suit will be said to have been contested. अब suit कैसे मानोगे? Suit कैसे contested है? समझो, हमारे पास 3 parties थे, A, B and C. एक सेकेंड, थोड़ा गड़बड़ हो जाएगा. हमेशा क्या होता है in proceedings, in real life proceedings, the name of the pro forma defendant is below. It is नीचे, last में दिया रहता है. So now it is A versus C and B is the suit. Now you cannot read it as such. If you want to understand conflict of interest, you cannot read it as such. The suit will be A versus B. Sorry, suit will be A versus C. एक part. The second limb of the suit will be whether it will be A versus B. No, it will not be A versus B because there is no conflict of interest between A versus B. The second is whether it will be B versus C. B versus C होगा? The answer to this is yes. It will be B versus C. because they have a conflict of interest between each other. So your suit will not be A versus B. The reason it will not be A versus B because there is no conflict of interest between A and B. The conflict of interest is between C and B. It is also between A and C, but it is not between A and B, A versus B. So you can say that the said suit will be contested. How it will be contested? It will be contested between A versus B and B versus C. It won't be contested A versus B. ऐसे contest नहीं होगा. ठीक है. अब देखो ये है, ये सूट है, A है, ये C है और ये B है. B is the pro forma. अब ये तो मान रहे हो कि आपके प्रोफॉर्मा और मेन प्लेंटिफ, प्रोफॉर्मा डिफेंडेंट एंड मेन प्लेंटिफ में कोई डिस्प्यूट बीच में नहीं होता, कोई कॉन्फ्लिक्ट ऑफ इंटरेस्ट नहीं होता. सो द क्वेश्चन इज हाउ विल यू, इफ यू वांट टू सी that how the suits are contested, if you want to see how the suits are contested, how will you say that, how are they contested? First, they are contested between A versus C. The answer is yes, they are contested between A versus C. Second, whether they are contested between A versus B, I would say no, because there is no conflict between A versus B. A और B के बीच में कोई conflict ही नहीं है ना, because B तो pro forma defendant है. So B is as good as the plaintiff. तो ये A versus B तो होगा नहीं. There is no suit is not contested between A and B. The second is whether the suit is contested between B versus C. The answer to this is yes. Even though they are co-defendants, but they have conflict of interest. They have conflict of interest. There is a conflict. So a suit is contested between them. So ये दोनों में सूट कंटेस्ट हो रहा है, इसमें सूट कंटेस्ट नहीं हो रहा. सूट इज नॉट कंटेस्ट बिटवीन A versus B. So this is what it is trying to say. The suit is contested between. So if you want to say that how between whom the suit is contested, so the original suit is contested. So the suit will be said to be contested. The suit will be said to be contested. The suit will be said. The suit will be said to be contested. Contested between original plaintiff. Between original plaintiff and defendant. And secondly, other defendant and pro forma defendant ठीक है, other defendant and pro forma defendant, and not between plaintiff and pro forma defendant. अब ये क्यों? The reason they are not in conflict with each other ना, उन conflict ही नहीं है उन दोनों के बीच में, तो उनके बीच में सूट कंटेस्ट करके क्या करोगे? डिसाइड करोगे, इश्यूज फ्रेम भी करोगे, उनके बीच में करके क्या करोगे? दैट विल बी फ्यूटाइल. दोनों एक ही लाइंस की प्लीडिंग्स पे फॉलो कर रहे हैं ना, वो बोलेगा मैं भी ओनर हूँ, वो बोलेगा मैं भी ओनर हूँ, तो उसमें इशू क्या फ्रेम करोगे? So the suit cannot be contested between plaintiff and pro forma defendant. The suit will be said to be contested between original plaintiff and defendant, other defendant, that is co-defendant and pro forma defendant. Simple as that. तो इस केस में सूट किसके बीच में कंटेस्ट हो रहा है? प्लेंटिफ और अदर डिफेंडेंट. प्लेंटिफ और प्रो फॉर्मा डिफेंडेंट के बीच में सूट नहीं कंटेस्ट हो सकता. प्रो फॉर्मा डिफेंडेंट और को डिफेंडेंट के बीच में सूट कंटेस्ट हो सकता है. दैट इज व्हाट इट इज टू से. क्लियर है? अब बताइए, इज इट क्लियर?
यस सर.
यस अहमद.
सर एक चीज समझ नहीं आई कि जो प्रोफॉर्मा डिफेंडेंट है, जो एक पॉइंट ऑफ टाइम पे डिफेंड कर रहा था, हालांकि कुछ डिफेंड नहीं कर रहा था, बट डिफेंडेंट था, तो उसको सडनली हम प्लेंटिफ किस पर्पस से बना रहे हैं?
एविडेंस लीड कर सके ना, एविडेंस क्या लीड करेगा, उसको डिफेंड थोड़ी करना है, रियल नेचर तो उसका ऐसा डिफेंडेंट है ही नहीं, उसको हमने नाम के लिए डिफेंडेंट बना के रखा है।
बट सर प्लीड भी क्या करेगा जब उसका कुछ
प्लीड
है
कर
नहीं?
प्लीड कर सकता है ना, अगर उसे कोई बात पॉइंट ऑफ रिकॉर्ड पे लानी है तो प्लीड कर सकता है ना, सिर्फ सुनता थोड़ी रहेगा हर केस में।
सर अपने इंटरेस्ट के लिए मतलब प्लीड करेगा?
अपने इंटरेस्ट के लिए या को ओनर के इंटरेस्ट के लिए, या एडमिट भी करना हो तो एडमिट करेगा। ठीक है, दिस व्हेन आपको लगता है कि एक्चुअली तो वो है प्लेंटिफ, बट हम प्रोफर्मा डिफेंडेंट इसलिए बना रहे हैं क्योंकि वो प्लेंटिफ बनना नहीं चाह रहा।
ओके ओके सर।
चलिए, now let's understand the second. This was the first term, that is parties. मतलब सेकेंड टर्म में पहले तो कॉज ऑफ एक्शन था, सेकेंड वाज पार्टीज। अब आ जाओ थर्ड टर्म पे। थर्ड टर्म में सब्जेक्ट मैटर। व्हाट डज सब्जेक्ट मैटर मीन्स? नाउ subject matter is basically a thing with respect to which the suit is contested. So it is a thing with respect to which suit is contested. आपका जो सूट है वो उसके रिस्पेक्ट पर कंटेस्ट हो रहा है, वो है। सो इट इज थिंग अपॉन विच द लीगल राइट इज इंसिडेंटल। मतलब आपका जो लीगल राइट है दैट इज समहाउ इंसिडेंटल और इफेक्टिंग दैट थिंग। सो बिकॉज ऑफ दैट थिंग योर लीगल राइट इज एग्जिस्टिंग। So because of that thing, your legal right is existing. That is subject matter. Now, it is basically thing with respect to which your suit is contested, and there can be two types of subject matter. पहला हो सकता है personal. ठीक है? Suppose you are seeking reservation. Caste will be a subject matter. It is a thing with respect to which your suit is contested. तो आप क्लेम करोगे ना कास्ट कि बस दिस इज द कास्ट आई एम, देयरफॉर आई एम सीकिंग अ रिजर्वेशन। सो दिस इज अ पर्सनल राइट, दिस इज नॉट रिलेटेड टू एनी प्रॉपर्टी, दिस इज अ पर्सनल राइट, दिस इज बेसिकली अ राइट रिलेटिंग टू यू इन पर्सोनम, इट इज अ पर्सनल राइट। द सेकेंड इज प्रोप्राइटरी राइट। प्रोप्राइटरी मीन्स दैट द राइट विच हैज अ कनेक्शन विथ एनी प्रॉपर्टी, legal right which is incidental upon any property. Suppose गाड़ी है, ये कार है, ये कार है आपके पास, ठीक है? सो कार से रिलेटेड जितने भी ये क्या बना दिया मैंने, कार तो लग नहीं रहा। Wait a sec. Suppose this is a house you have. Now all the rights relating to this house are known as proprietary rights. जैसे right of ownership, proprietary right, right to enjoy, proprietary right, right to receive rent, proprietary right. All the rights that you have related to a particular property, wherein property is the subject matter, those rights are known as proprietary right. जहां पर प्रॉपर्टी एक बहुत ही बड़ी भूमिका निभाता है, प्रॉपर्टी और इज द सब्जेक्ट मैटर, इज द मेन थिंग ऑन विच द लीगल राइट इज क्लेम्ड। सारे राइट्स प्रॉपर्टी के ऊपर क्लेम हो रहे हैं ना, प्रॉपर्टी के थ्रू क्लेम हो रहे हैं इनफैक्ट। So those rights are known as proprietary rights. Those rights are known as proprietary rights. And the rights wherein there is no involvement of property. No property is involved. Rather, they are existing because of they are personal to you. Because of your personality or because of your personal nature, they are existing. So those rights are known as personal right. उनको आप बोलोगे personal right. Fine. So now your subject matter can be your subject matter in personal, it can be in personal right. You can have a subject matter in a suit that is of personal right. You can have a subject matter in a suit that is of proprietary right. So दोनों भी हो सकते हैं, personal भी हो सकते हैं, proprietary भी हो सकते हैं, ठीक है? So basically subject matter is a thing. ये लिखो एक बार, subject matter is a thing. Subject matter is a thing. Is a thing upon which legal right is incidental. upon which legal right is incidental, or the thing with respect to which a suit is contested. ये क्या हो गया? Subject matter can be personal. Subject matter. SM is subject matter, guys. Subject matter can be personal or proprietary. ठीक है? So now what does personal means and what does proprietary means? So wherever a suit is contested, wherever the suit is contested with respect to some property, or any right related to property, it will be called proprietary. It will be called proprietary subject matter. ठीक है? If no property is involved, ये proprietary subject matter है. If no property is involved, कोई property involved ही नहीं. If no property is involved, then it is personal subject matter. If no property involved, then it is personal subject matter. अगर कोई property involved नहीं है, तो उसको आप बोलोगे personal subject matter. Fine. जैसे reservation on the grounds of caste, no property involved. A claim of dower, no property involved. Meher जिसको बोलते हैं, no property is involved. Claim of maintenance, again, no property involved. Only a personal right is created because of marriage. So these rights are personal in nature, wherein no claim is not on property. If the claim is on property, that will be a proprietary subject matter. Okay, by proprietary. Fine. Now, how do you understand the nature of? How do you examine the nature of? ये लिख लिया आप लोगों ने?
Yes, sir.
ठीक है. Now the question is, how do you examine the nature of subject matter? कि ये subject matter personal है, proprietary है, कैसे examine करोगे? So simple है कि if you want to understand the nature of subject matter, in all cases you will have to examine cause of action. So nature of subject matter समझने के लिए you must examine cause of action. Cause of action examine करना चाहिए आपको, तब आप समझ जाओगे कि ये proprietary है या ये है. So if the cause of action is connected with some property, then it is proprietary. If the property is not involved, then it is personal. So if cause of action is connected with, if COA is connected with property, then it is proprietary. ठीक है? No property, then it is personal. ठीक है? COA, cause of action. COA is cause of action. ठीक है? पीछे करें, आगे बढ़े गाइस. हो गया?
Yes, sir.
So last slide.
यही ना, ये वाला. अब देखो, एक टर्म है where all people are very confused. That is a difference between remedy and relief. मतलब what does relief mean and what does remedy mean? इनमें फर्क क्या? रेमेडी में क्या फर्क है and relief में क्या फर्क है? So this is an important difference that we have to understand. That is remedy and relief. Can they be interchangeably used? Or can they be interchangeably used? Can they be discussed in such a manner that we can use them interchangeably? क्या इनका मतलब सेम है? That is one of the questions that is generally posed. See, in terms of meaning, remedy and relief, they mean the same thing. Relief is also a remedy. Relief is basically a sort of a remedy that you are asking from the court. But in terms of law, they are different. See, remedy is the word that we use in substantive law. ठीक है? Substantive law में say Contract Act. In Contract Act, when we say that a person is entitled to a remedy of section damages, so we are saying that the damages is the remedy. Damages is the remedy. But the moment that damage you are claiming in court, the moment आप यही डैमेज क्लेम कर रहे हो कोर्ट में, यही डैमेज क्लेम कर रहे हो कोर्ट में, वो रिलीफ बन जाता है. ठीक है? So when it is stated in substantive law that in case of violation, the remedy, in case a remedy, if it is not violated, मतलब एक सब्सटैंटिव लॉ जब हम बनाते हैं, हम ये बोलते हैं कि अगर ये वायलेट हो गया तो ये रेमेडी होगी. सो इन सब्सटैंटिव लॉ अ पर्टिकुलर solution or redressal is known as, in substantive law, a particular redressal is known as remedy. But the moment you are claiming this remedy in the court, we call it relief. The moment you are claiming this remedy in court, हम इसमें बोलते हैं, इसको relief बुलाते हैं. तो फर्क कुछ नहीं है दोनों में. There is no difference. Only the terminology is different in procedural law. In procedural law, we call this remedy as relief. The reason we call it, when a remedy mentioned in book, a remedy mentioned in substantive law, a redressal mentioned in substantive law is called remedy. The moment you are going to court and the moment you are claiming it, वो relief बन जाता है. बस इतना ही different है. So procedural में when you are putting a remedy into effect, वो relief बन जाता है. As it is books पर है तो वो remedy रहेगा. So this is the one major difference, और कुछ नहीं है इसमें. In fact, many times it has been used interchangeably. So you can say that remedy is that which is granted by the substantive law, in case of violation, in case of violation of legal right, in case of violation of legal right. ठीक है? The same remedy will be called relief. वही remedy, कुछ अलग नहीं हो रहा. It is not changing its nature. ऐसा नहीं कि अलग हो रहा है. The same remedy will be called relief. The same remedy will be called relief the moment it is claimed in court. The moment it is claimed in court. The moment it is claimed in court, in a suit, or it is granted by court in a suit. ठीक है? अब एग्जाम्पल लिखो. लिखेंगे एग्जाम्पल?
Yes, sir. Yes, sir.
फॉर एग्जाम्पल.
सर एक मिनट प्रीवियस स्लाइड दिखा.
हाँ जी देख लीजिए. So remedy is the word that we are using for a redressal in substantive law. The same thing that the moment it is claimed in courts, जैसे ही आप मांग रहे हो कोर्ट में या कोर्ट ग्रांट कर रहा है, वो रिलीफ बन जाएगा. बस इतना आपको याद रखना है. ठीक है? सब्सटैंटिव के लिए उसका नाम अलग है, प्रोसीजरल के लिए उसका नाम अलग है. फाइन, आगे बढ़े. ठीक है, let's proceed. So for example, in the case of breach of contract, under section 73 of Indian Contract Act, that is ICA, damages is the remedy provided. ठीक है, is the remedy provided, but the moment a suit is filed, it will be called relief. ठीक है, and later when the court grants it, the damage will be called relief. Later when the court grants it, it will be called that the relief has been granted by the court, that the relief of damages has been granted by the court. Okay, it will be called that relief of damage has been granted by court. ठीक है, क्लियर है?
Yes, sir.
ठीक है, what is the time? ठीक है, I wanted to start title. चलो 2 बज गए हैं, 2 terms are remaining. One is title and the other is matter in issue, and then our beautiful chart will come to an end. एक बार मैं introduce कराता हूँ chart से, so that you can understand, and we'll do a fun exercise उसके बाद, wherein we'll see 5 or 10 cases, 5 cases basically, and we will analyze title and matter in issue. सब निकालेंगे हम कि इसमें matter in issue क्या है. 4 केस देखेंगे, ज्यादा नहीं देखते. We'll analyze matter in issue ये. तो बेसिकली फन चार्ट ये है कि एक मैटर इन इशू होता है, मैटर इन इशू बनाता है टाइटल को. ठीक है, टाइटल गिव्स अ राइज टू कॉज ऑफ एक्शन, कॉज ऑफ एक्शन से आप मांगते हो रिलीफ. तो दिस इज द सर्कल ऑफ लाइफ और सर्कल ऑफ अ सूट. ये पहले मैटर इन इशू आता है, फिर टाइटल आता है, फिर कॉज ऑफ एक्शन आता है, फिर रिलीफ. टुमारो वील अंडरस्टैंड द रिलेशनशिप बिटवीन मैटर इन इशू and title. We have understood cause of action and relief. These terminologies itself are very important to proceed further, क्योंकि कहीं जगह पे ये यूज किया हुआ है. तो we need to understand what exactly title means, किस सेंस में यूज कर रहे हैं, क्योंकि title otherwise can mean a lot of things. So we have to be specific what exactly they are trying to aim at. तो इसके लिए हमें कंसिडर करना पड़ेगा. सर प्रीवियस स्लाइड. यप, ठीक है. सो दोज हु गाइस वांट टू लीव दे कैन लीव. जिनके डाउट्स हैं बताइए, मुझे पूछिए. यस मुस्कान. Yes, Muskan.
Yes, sir. This doubt is not related to any concept, but the way we write CPC answers. So what happened in law school is one of our teachers told us that in CPC Bare Act, the orders are written in Roman numerals. So when we write our answers,
Roman.
In Roman only.
Yep.
Okay, it will lead to deduction of marks if we don't
divide by it doesn't result into deduction of marks if your concepts are solid, so it won't matter also. It's a mere technicality that can be overlooked, but don't avoid write it in Roman. Most teachers prefer it, especially in UP. The exams and the papers are not checked by your judges. Papers are checked by academicians, and they want everything by the book. They don't want they are particular about these small things which
Hmm.
don't matter much, but वो लिख लो, उसमें क्या है, ठीक है, keep them also happy, ना, why should say they be sad? Yes, Mansi.
सर आपने स्टार्टिंग में जो बताया था प्लेंटिफ डिफेंडेंट एप्लीकेंट वाला बता देंगे एक बार के
कि
फर्स्ट
प्लेंटिव
साइड में जो
मतलब, हाँ मैं ये बोलने की कोशिश कर रहा हूँ कि 3 चीजें हो सकती हैं, कि 3 तरह की पार्टीज हो सकती हैं एक सिविल सूट में. इट कैन बी अ प्लेंटिफ एंड अ डिफेंडेंट, वो नॉर्मली यूजुअल केस में होता है, ऑर्डिनरी में. बट अगर सिविल रिट हो गई, सपोज सिविल रिट है, तो क्या करोगे? तो उसमें पेटिशनर होगा, रिस्पोंडेंट होगा. अगर डिवोर्स पेटिशन एप्लीकेशन है, या डिवोर्स पेटिशन में तो पेटिशनर रिस्पोंडेंट होगा. अगर कोई एप्लीकेशन है, सिविल एप्लीकेशन है, तो उसमें क्या, एप्लीकेट और रिस्पोंडेंट होगा. सिंपल, यही तो बोला. ठीक है, चलिए. यस प्राची.
So could we please go back to the slide in which you were explaining joinder of parties? He has the capacity to obstruct.
Pro forma defendant.
Yes, sir.
Here. No, not here. Here, ये भी नहीं था. ये था ना. This one. Or here.
No, sir. In which you were making us write.
This one.
Yes, sir.
ठीक है. Yes, Vartika.
सर मेरा डाउट असाइनमेंट से रिलेटेड है.
क्या?
सर असाइनमेंट में लास्ट पॉइंट जो हमें अप्रोच में दिया गया, गिव सम एग्जांपल्स व्हेन प्रोहिबिटिव प्रोविजंस कैन बी रेड एज डायरेक्टिव, तो इसमें हमें केस लॉज जो आपने बताए थे वो लिखने हैं या फिर
ऑर्डर 8 का
इलस्ट्रेशन?
ऑर्डर 8 का एग्जांपल दे दो ना. ऑर्डर 8 रूल 1 को कैसे हमने डायरेक्टिव पढ़ा है.
ठीक है सर.
ठीक है. यस अंशिका.
Sir, I have a doubt with respect to the flow chart जो आपने लास्ट में बनाया था. Sir, how matter in issue is coming before cause of action?
Matter in issue is the source of title. Matter in issue के वजह से टाइटल बन रहा है. फिर टाइटल से आपका कॉज ऑफ एक्शन अराइज हो रहा है, कॉज ऑफ एक्शन से फिर रिलीफ हो रहा है. कल समझाऊंगा, कल मैटर इन इशू समझेगा आपको. सोर्स ऑफ टाइटल है वो. टाइटल मैटर इन इशू की वजह से बन रहा है. ठीक है, वो मैटर इन इशू नहीं है जो आप समझ रहे हो, वो सेटलमेंट ऑफ इशू, वो अलग है.
Okay, sir. Because sir, reason of the suit is cause of action. तो
reason of the suit is cause of action. source of title is source of title, जिससे टाइटल बन रहा है, जिससे टाइटल शुरू हो रहा है. जैसे टाइटल ओनरशिप है, कैसे आ रहा है? क्या वो इंटरेस्ट सक्सेशन से आ रहा है, विल से आ रहा है? तो दैट इज मैटर ऑफ इशू.
okay, sir.
दैट इज मैटर इन इशू. ठीक है, बेसिकली सोर्स ऑफ टाइटल. यस अंचित.
So will you please clear a relief and remedy once again when where you make a flow chart?
Yep. See, whenever a redressal is provided in substantive law, say Contract Act, damages is the redressal. So in that case, we call it remedy. But the moment it is claimed in procedural law in court, then we call it relief. उसको अगर जैसे ही सब्सटैंटिव लॉ में प्रोवाइडेड है उसको हम रेमेडी बुलाते हैं, बट जैसे ही वो मांगा जाता है कोर्ट में उसको हम रिलीफ बुलाते हैं. ठीक है.
Okay, so thank you.
यस निग्धा.
तो आप परफॉर्मर डिफेंडेंट का एक एग्जांपल देंगे कि एक्चुअली रियल लाइफ में कैसे हम लोग अटैच करते हैं कोर्ट में?
नहीं, इवन यही ऐसे ही केसेस रहते हैं कि इवन यूजुअली व्हेन सपोज सी लेट अस टेक अ एग्जांपल ऑफ अ मूवी. say let us take, there are 2 producers. ठीक है, and one producer, and the movie has been pirated. Someone is committing piracy, copyright claim है. This copyright belongs to both of them, 1 and 2. Now here what happens, one does not want to indulge into this copyright suit because he feels that it will be a waste of money, it will waste time. So what he will do, he will choose not to file a suit. Says that I don't want to file a suit. But now your 2 feels that problem will arise if he is not added. So he files a suit against the normal defendant and he makes one as a pro forma defendant. इसको pro forma defendant लेते हैं. अब क्या होता है, ट्रायल के दौरान A wants to produce some evidences to support that कि copyright claim अब ये प्रूफ कर नहीं पा रहा कॉपीराइट क्लेम, मतलब ये एग्जैक्टली कॉपीराइट प्रूफ नहीं कर पा रहा है कि क्या वायलेशन है या क्या है. Now this person wants to lead evidence, so in that case he will have to be transposed. So the court will transpose him. He can file an application, he will be transposed and he can lead evidence, get it done with. ठीक है.
अच्छा सर, मतलब अगर मैं परफॉर्मा डिफेंडेंट के आंसर में ये वाला एग्जांपल लिखूं तो चलेगा?
चल जाएगा, बट वो बेटर है ना, वो एग्जांपल क्लियर है ना ज्यादा. आप ये क्यों लिख रहे? डिटेल
सर
में
एक्चुअली मेरा इंटरनेट चला गया था तो वो एग्जांपल ही मिस हो गया मेरा.
वो एग्जांपल सिंपल है. एग्जांपल वो ये है कि ये प्रॉपर्टी है सपोज इतनी बड़ी, इसके जॉइंट ओनर्स ए और बी. सी आता है, सी ए और बी को किक आउट कर देता है. फाइन. तो अब क्या होता है कि A says that I want to file a suit against C. B बोलता है बॉस मुझे मत धकेल इसमें, मुझे नहीं आना इसमें, मुझे इस मसले में नहीं पढ़ना, you file a suit. तो A says that fine, I will file a suit against C. But the problem is कि अभी ये सूट में ना टाइटल दोनों का डिसाइड होगा, बिकॉज बोथ आर जॉइंट ओनर्स है ना, दोनों जॉइंट ओनर्स हैं, दोनों का टाइटल डिसाइड होगा. एंड प्रॉब्लमैटिक एक सिचुएशन हो जाएगी कि बी के बिना प्रेजेंस में बी का टाइटल डिसाइड हो रहा है. So B will be in a position to obstruct the execution. तो इसमें क्या होगा, A will put B as a pro forma defendant. ये एग्जांपल लिखना एग्जाम में. ठीक है.
ठीक है सर, थैंक यू.
चलिए see you tomorrow guys. मतलब see you in the evening. चलो bye guys.
Thank you, sir.
Thank you, sir.